Perfect. And the garbage truck comes just at the right time. Well, great. Is it 3 o'clock in the afternoon? Sure it is. Am I gonna start drinking anyway? You bet your sweet ass I am. You know, lawyering can be a little annoying sometimes. In fact, hold on. Where's my emotional support bird? Emotional support birdie. Hi. Meow, can I take you? Come here, my sweet little bird. I need emotional support. Thank you, birdie. I found her. Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado. Welcome back to All Up in Your Business, where today me and Little Bird are going to answer your questions and talk shit about one of your comments. Just kidding, kind of. Oh hi, here comes my emotional support dude. Hey Pally, everyone's here. It's family time at All Up in Your Business. Oh, Bird's leaving. You're a terrible emotional support bird. As I mentioned, I'm gonna go through your comments, answer your questions, drink some wine. Today I have a lovely Sauvignon Blanc from Trader's Joe. I'm not gonna try to pronounce it. It's that one. I don't care. Who cares? This is, okay. Before we get into all that fun stuff, make sure you subscribe if you haven't already done so. Click the little bell so you get notified when I post a new video. Check the description for links to additional information and resources. And most importantly, have fun. And of course, I am a lawyer, but I am not your lawyer. The stuff I talk about in my videos isn't a substitute for actual legal advice. If you need help with any legal matter, you should consult with a lawyer who's licensed in your state. Birdie, you're really gonna just ditch me like that? That's so rude. Little bird, come on. Here, why don't you hang out there? That's nice. That's a nice spot for a little bird. Yeah. Just stay there. She's gonna be mad. She's mad I took her. Yeah, just stay there. And with no further ado, let's get to some of your questions. This is great info. However, what if the business takes off, then someone usurps, hijacks the name and trademarks ahead of you? This is a trademark related question, of course. Bird, fine, Bird's out of here. This is a trademark related question, of course. I think it's from one of my videos where I talked about how like you don't need to get a trademark registration to start a business, particularly if you have a really tight budget, don't have a whole lot of money to put into it. Sometimes it's not the best idea to put what few funds you have into a trademark registration because you don't really need it. It's a great idea, but you don't need it. So what happens if someone usurps or hijacks the name and trademarks it ahead of you? A lot of things can happen. It depends, of course. If that does happen, you usually have some options for either opposing or canceling that trademark registration. That is, of course, assuming you have first use of the trademark, or in other ways your rights are greater than whoever has already registered it. If that's not the case, then, you know, you might be kind of SOL and you might have to rebrand, but that could still happen anyway. Even if you have a trademark registration, if someone else comes around and thinks that they're entitled to that registration because they have an earlier date of first use or something, they can still try to oppose or get your registration canceled anyway. So, you know, if someone gets to it and trademarks registers a trademark before you do, but you've been using it this whole time, your best option in that case would be to try to get that registration canceled. Thank you, you're welcome. Can I run an LLC for 5 years without paying myself or taking a distribution, reinvesting profit for growth? Yeah, that's fine. You don't have to pay yourself. Assuming you're not taxed as an S corporation. If you are taxed as an S corporation, then you do have to pay yourself to an extent, but you don't have to pay yourself in an LLC. You can keep it all in the business and reinvest it in the business. You are still going to be paying taxes on that though. So don't think that just leaving it in the business is going to get you out of paying taxes. Like I said in one of my previous videos, my most recent one, I think, one of the previous ones, it doesn't matter how much or how little you pay yourself, you still have to pay tax on your business's income. Speaking of S-Corps, I operated as a S-Corp and have employees that I pay on W-2. Do I still need to pay myself? Yes, if you are operating as an S corporation, if you're taxed as an S corporation, the IRS requires that you pay yourself a reasonable salary. What exactly a reasonable salary is, it depends, I can't tell you, but yeah, you have to pay yourself something if you're taxed as an S corporation. When you say you have to monitor other trademark applications, do you literally mean that you have to once you have a trademark, or do you mean if you want to enforce it, then you have to do those things? A little bit of both. I guess you don't literally have to, like you know, no one's going to come, the USPTO isn't going to come like knocking on your door and throw you in jail if you're not monitoring it. But first of all, like, what's the point in a trademark registration if you're not going to take steps to enforce those rights and uphold the rights that the trademark gives you? There's also this idea of a trademark dilution, which really only typically applies to like big famous trademarks, famous brands. But if there are others out there that are kind of similar to your trademark and you're letting them all slide, it can dilute your brand and the strength of your trademark or your brand and the distinctiveness of it. And there's also this thing called the doctrine of latches, which basically says that if you don't enforce your trademark rights, eventually you'll lose them, because again, what's the point of having them if you're not going to enforce them? The government, the USPTO, is giving you this registration under the expectation that you're going to do something with all of these rights that you now have. If you're not going to bother doing that, then why would they bother giving you the registration? So under this doctrine of latches, if you don't take reasonable steps to enforce and monitor your trademark, you could potentially lose it. So do you need to? Literally no, but you still kind of do have to. Okay, this is a strap in, you guys. Hayden's about to go on a little rant. Get to the point. Yeah, I'm here to waste as much time, pointless time, as possible. Why waste people's time with the cat? You guys can see that I've already responded to this, but I'm putting it here just for funsies. And this was, I don't know, one of the videos where the cat showed up and delayed it a little bit, kind of like it did today. And guess what? Why I do that? Because it's my channel, and doing things like that, like having Little Bird in the video or when Rocky walks in, those things make it fun for me to keep doing this. And man, nothing chaps my ass quite like when someone complains about the way I present this free legal information. If you want effective, quick, spot-on answers and legal advice tailored to you, you can pay a lawyer for it. But if you're going onto YouTube looking for free information and then you go complain about how it's given to you, I just don't get it. I'm here to waste as much time as possible. No, you're here to get free legal information. So take it as I'm giving it to you, or go elsewhere, or pay a lawyer if you want it presented to you in the way that you want. Okay, thank you. Okay, rant over for now. I'm gonna keep drinking. Man, that's annoying. If I create training documents and shared them as part of my brand with an organization, does that give the organization the right to use and modify my document? Strictly speaking, no, but of course it depends on the context and the situation. Hopefully you have an agreement with this organization, a license agreement that specifies exactly how that organization can use and maybe modify that document. Outside of that though, Rocky. Outside of that though, you know, it comes down ultimately to just kind of general copyright laws. And if you created the training documents, presumably you own the copyrights in them. And so this other organization can only use or modify them to the extent that you permit them to. Again, it depends on the context and the situation, but the strict answer is no. They can't. But then on the flip side, if you created this document for them, for this organization, presumably you did it so they can use it and maybe distribute it throughout their organization or use it to some extent within their organization. So you gotta kind of keep that in mind too. But like, they can't make copies, photocopies of it and give them to everybody or start selling them. They certainly, well, they can do it. It's unlawful kind of, but that's not the right thing to do. Your copyrights would give you some rights in that instance if they copied it. That doesn't, however, protect whatever information might be in those training documents or kind of the concepts or ideas behind it. So let's say this organization took your document and took that information and created their own document out of it. That may be something that they're able to do, and you might not be able to do anything about it. But again, it all depends. It all depends on the context and situation. If all the money goes into your business bank account and never gets used for personal use, How do you get paid? I included, there's a response here as well. It says, hey, I'm a bookkeeper. You can take something called an owner's draw or you can pay yourself a salary. And that's exactly correct. Paying yourself a salary or taking an owner's draw isn't using the money for personal use. It's taking a distribution of the profit, which is something that the business and the owner can do. That's not using it for personal use. That's taking it for yourself, and then you can use it for personal use. But yeah, that's the answer. You take it as a draw or a member distribution, or if you're taxed as an S corporation, then you might take it as part of that reasonable salary as well. So how do nonprofit organizations that don't make any sales actually trademark their logo and stuff? This, I assume, comes up because in many of my trademark videos, I talk about use and how you have to use a trademark for it to be a trademark, and you have to be using the trademark in commerce if you want to get it registered. And generally the easiest way to explain what use in commerce means is that you've sold your products or you sold your services under that trademark. That doesn't mean you have to be in a for-profit business. Nonprofit organizations can get trademark registrations just like any other business. Use in that instance might be once your organization first started pursuing whatever its goals or purpose is under that logo and stuff. The service, like the goods and services description for a nonprofit organization might be, promoting public awareness of whatever subject matter. And so as soon as you have started using the trademark in connection with promoting public awareness of that subject matter, you've used it in commerce and you can register the trademark for it, assuming it's available and, all that other stuff. It's actually registrable and unique and all that fun stuff. Does first use apply to the phrase or specifically the logo as it is up to date? For example, I've been using the phrase of the logo since 2012 in internet posts, but not sold them. That came in 2022. The logo has been updated and finalized. Is it the phrase or logo that I have in mind in this circumstance? So I think what this is asking is the date of first use. Is that the date of first use of the logo or the phrase or the catchphrase? They are two different trademarks, the logo and the catchphrase, and so they can have two different dates of first use. If we're talking about a logo that has the phrase as a part of it, then the date of first use would be the date you started using that logo. If you use the phrase outside of that logo, then that date of first use would be when you first started using the phrase, either in or outside of the logo. But ultimately, they're two different trademark registrations and two different trademarks, so it's most likely that they'll have two different dates of first use. Hello, great video. Just one question. If I trademark my business for one service in a single class, but later on I decide I want to branch out to other things that would fall into different classes, do I need to trademark for the new services too, or can I just stick with the single class that I applied with? Do you need to do an additional trademark registration? No, it's typically going to be the right thing to do and usually advisable in that instance. Your trademark registration applies to the goods and services that you identify on the application, as well as any related goods and services or natural extensions thereof. So if the second class that you are starting to deal in, if it's pretty closely related, if it's pretty darn similar to that first initial class, it may not give you a whole lot of added benefit to do an additional registration in that new class. It's still usually going to be a good idea though, because just best thing is to protect it as broadly and as much as you can. If they are two completely unrelated, two separate goods or services, have nothing to do with each other, then yeah, it's going to be a good idea to do an additional trademark registration for that new class of goods and services. All right, last one, you guys, and then I'm gonna sit on the couch and just breathe for a while and not listen to anybody. I got so many people talking to me today. Oh God, does anyone else just get like totally burnt out having conversations with people all day? I work by myself in my house because I don't want to talk to people all the time. It takes a lot of me. Anyway, I have a logo, but I'm not a business owner. I have a great logo and I want to start my business after I retire in 2 years. Can I still register a trademark now? Let's read what you said. I have a logo, but I'm not a business owner. You have a logo. You don't have a trademark yet. Your logo is just a picture, a design. You're not using it for anything. So can you register a trademark now? No, because it's not a trademark to register yet. Does that mean you can't start the process of trademark registration? Certainly not. You can do that if you have a bona fide intent to use your logo in your business. Then you can apply on an intent to use basis. And then eventually, once you have started the business and have started using the trademark, then it will be registered. But you can't register a trademark now. You can start the application process now. Okay, that's it, you guys. Give me a thumbs up if you learned a thing or two. I don't know. Did you? I don't know. Give me a thumbs up if you like Sauvignon Blanc, or, you know, if you just feel like it. What else? Subscribe, bell, click the little bell if you haven't already done so. Check the description for links to additional information and resources. If you're looking for help with a trademark registration, you know who to talk to. All my contact info, well, not all of my contact info, but you can find how to contact me down there in the description. Thank you all so much for watching. Really, I know I feel kind of, I talked bad about that one comment. Most of you, the overwhelming majority of you, leave wonderful, really nice, appreciative comments, and that's really why I keep doing this. So I really do thank you all for being here. That one guy, you can go somewhere else, but I thank you all so much for watching. I'm Aiden Durham, and I'll see you next time. Okay. Oh, God, yeah. All right. All right, nap time. Nap time.